Alright, so open and obvious doctrine. This is a legal defense in a negligence injury case, and it applies to a slip and fall or a trip and fall, where someone may be injured if they slip on a wet floor, or if they're walking down the sidewalk or the street and there happens to be a pothole that they step in and they break their ankle or twist their ankle. That's where this open and obvious defense comes from. So, the basic gist of the defense is a property owner shouldn't be liable for a slip and fall or a trip and fall injury because whatever the defect is, whether it's liquid on the floor or a pothole, is so open and so obvious that the person who injured themselves should have been able to see this defect or this substance on the floor, that they should have been able to take evasive action on their own and really shouldn't be rewarded for injuring themselves when the injury causing defect was just so in front of them and obvious that it easily could have been avoided. It's a favorite defense of insurance adjusters and insurance defense attorneys because it is a complete bar to recovery. If a property owner or defendant in a injury lawsuit successfully asserts this defense, it's a complete bar to recovery. The injured person's not going to get any compensation whatsoever for their injuries, for their medical expense, for any of their damages. There are some ways around this defense. One, it only applies to the property owner. If there's a contractor in charge of paving a sidewalk or maintaining the property and they cause the defect, this third-party contractor, non-owner, can assert the defense. If there is a statutory violation, the landowner cannot assert an open and obvious defense. And even if a court would say or would determine that the defect, whatever it be, again, some liquid on the floor or a pothole in the sidewalk or on the street, even if it is open and obvious, there's something called attendant circumstances, which are basically just circumstances surrounding the entire event of that specific factual situation that can really get rid of the defense. So going to a pedestrian stepping in a pothole on the sidewalk, what's the pedestrian traffic like? What's vehicular traffic like? What else is going on? Was there some sort of distraction, something to avert the injured person's eyes? All those factors can sort of obviate the defense in the injured person's favor, and it's all factual specific. You really would have to get the facts of specific injury to really determine whether the attendant circumstances would be enough to get rid of the defense. There's a lot of case law out there on it, and so it's all about just comparing the case law to each person's individual circumstances. So even though open and obvious is a complete bar to defense, and defense attorneys really like to assert this defense for slip and falls and trip and falls, there are some ways around it, and that's why you really should find an experienced attorney when you find yourself in such a situation.